Everyone. Good afternoon and welcome to the Committee for Justice's virtual panel discussion, New Technologies, Same Principles, the Conservative Case Against Weaponizing Antitrust Law. I'm your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. I'm now going to briefly introduce our speakers in the order in which they're going to be speaking. So first we have Darren Basque, who's a senior research fellow at the Heritage Foundation, where he works on a wide range of issues from antitrust to property rights and environmental regulation. Before joining Heritage, Darren served as a policy counsel for the U.S. Chamber of Commerce, working on regulatory reform and environmental policy, and was the director of legal and regulatory studies for one of the leading state-based free market think tanks, the John Locke Foundation, located in North Carolina. Darren serves on the Federal Society's Administrative Law and Regulation Executive Committee and the Regulatory Transparency Project. He is frequently cited and published in media outlets such as the Wall Street Journal, USA Today, and Washington Times. It also publishes academic-oriented pieces, including a forthcoming law review article in the Food and Drug Law Journal on strengthening the Information Quality Act. He recently co-authored Heritage's A Conservative Guide to Antitrust and Big Tech. Jan Rybanek is Jan, I mispronounced your name again. I'm sorry about that. I'm just reading off of paper here and I sometimes mess up there. Let's do that again. So Jan is an attorney at Freshfields Bruckhaus Derringer in Washington, D.C. He represents clients on antitrust issues relating to the U.S. merger control and review process, multi-jurisdictional merger review, joint ventures, civil antitrust litigation, and investitures before the U.S. Department of Justice and the FTC. Prior to rejoining Freshfields in 2015, Jan served as an attorney advisor to former Commissioner Joshua Wright of the FTC. He served Commissioner Wright on a wide range of competition and consumer protection issues, including providing enforcement recommendations, developing legislation and policy initiatives with Congress, and drafting formal statements, policy speeches, and congressional testimony. Jan has published several articles on antitrust law and policy. He was awarded the 2017 Antitrust Writing Award, a joint initiative between the Concurrences Review and George Washington University Law School, in the Best Academic Mergers category for his article, A Hedgehog in Fox's Clothing, the Misapplication of GUPPI Analysis. Jan is an active member of the ABA's antitrust section and currently serves as an editor for the Antitrust Law Journal, a leading publication for antitrust law, policy, and economics that is widely read by the antitrust bar. Sorry, I tend to just read things off of my paper verbatim, including like insert notes here. So instead of doing that, let me give you the instructions for the housekeeping rules around here. So if you have a question for the audience, if you could just send it through the Q&A function that you see at the bottom of your screen. That makes things a lot easier for me. You can send them at any point during the panel, and I will then just kind of integrate them into our conversation later. So feel free to shoot those my way at any point during the panel. And with that, Darren, the floor is yours.
Thank you, Ashley, and thank you, Jan, for participating today. And I want to thank everybody, for all of you, for participating and also watching this video after today. So for as long as I can remember, antitrust has not received the attention and interest that it's receiving now. And it certainly hasn't led to such intense feelings like we're seeing. And this attention and interest is coming from people across the political spectrum. So today I want to discuss why conservatives shouldn't weaponize antitrust. And for my purposes, weaponizing antitrust means using antitrust law not merely to punish disfavored industries, but also to radically change antitrust law to make it much easier for the federal government to reshape industries and even the entire economy. My remarks today are based on a new Heritage report that Ashley mentioned that I co-authored with my colleague Gabrielle Beaumont-Smith, entitled A Conservative Guide to the Antitrust and Big Tech Debate. And you can find that on the Heritage website at heritage.org. So let us get straight to the elephant in the room. Conservatives have a valid reason to be angry with some big tech companies. For example, there are genuine concerns that speech is being censored. And honestly, I'm always amazed at how tone deaf some of the companies can be. So some conservatives are looking to federal policy solutions. If there are policy solutions adopted, though, then they should be narrowly crafted to address the specific issues of concern. For example, one of my colleagues has written a new paper arguing for the reform of Section 230 of the Communications Decency Act. However, trying to apply antitrust to concerns over bias and censorship by big tech is like putting a square peg into a round hole. Antitrust is focused on the competitive process, and it's not designed to address completely different issues such as bias and censorship concerns. Antitrust remedies can be like a sledgehammer to a business or industry. Conservatives are concerned with excessive federal regulation, and they definitely should be. So that being the case, it therefore makes little sense to look to antitrust as a policy solution in this context. Antitrust makes targeted regulatory solutions look modest in comparison with the potential sweeping remedies that can arise through antitrust enforcement. In addition, antitrust and weaponizing antitrust, as some would like, would not merely affect the technology sector. It would apply across the entire economy. But there are two especially important points that I want to bring up as to why weaponizing antitrust would be a disaster from a conservative perspective. First, one of the major conservative achievements over the last 40 years is the adoption of the consumer welfare standard. Conservatives shouldn't undo this achievement. They should be fighting to preserve it. Early antitrust law was inconsistent and unpredictable and reflected a desire to protect small businesses and achieve vague political and social objectives. During his Senate confirmation hearing, Justice Scalia humorously explained the past incoherence of antitrust law. Quote, "Indeed, in law school, I never understood antitrust law. I later found out in reading the writings of those who now do understand it that I should not have understood it because it did not make any sense then," end quote. Numerous conservative scholars, such as Robert Bork in his landmark book, The Antitrust Paradox, helped to shape modern antitrust law doctrine and give it some much needed focus. To these scholars, antitrust law should be concerned solely with economic welfare, as opposed to some approach that includes vague non-economic objectives. And it should help to ensure that consumers are protected from anti-competitive behavior. In 1979, the United States Supreme Court in the case Ryder versus Sonotone Corporation, citing the antitrust paradox, concluded, quote, "Congress designed the Sherman Act as a consumer welfare prescription," end quote. The consumer welfare standard approach have won the day. So the last thing we should want to do is go back to the early 20th century and adopt incoherent antitrust law. Now, my second critically important point. Some on the far left would love to put antitrust on steroids and punish the success of businesses. They think businesses that become big in and of itself is a bad thing, and the federal government is capable of knowing what the concentration levels within industries should be. Nobody has that knowledge. Even worse, they want antitrust to look at issues beyond competition and consumer welfare, such as labor rights and political corruption. In October of this year, the House Judiciary Committee's Antitrust Subcommittee released a majority report regarding digital market competition. The report recommended, among other things, legislation to change the business structure of dominant internet platforms and limit the markets in which they can compete. But the report's extreme recommendations were not limited to the technology sector. Representative Jim Jordan, ranking member of the House Judiciary Committee, succinctly explained that the report, quote, "advances radical proposals that would refashion antitrust law in the vision of the far left," end quote. Conservatives shouldn't let anger towards some in big tech serve as an excuse to give the far left the ability to weaponize antitrust. And this new weapon the far left would have in its arsenal would be a weapon of mass destruction. It could be used to go after industries unrelated to big tech and to reshape the entire economy consistent with their ideology. I want to stress that antitrust law should be applied to the technology sector just as it applies to other sectors of the economy. There should be no favoritism one way or another. And I also want to stress that many tech companies are definitely extremely powerful. There's no question about this point. But conservatives should strongly reject efforts to turn antitrust law into a weapon that addresses issues that antitrust law isn't even designed to address. Nor should antitrust law be radically changed to increase the federal government's control over the economy. Conservatives are the stalwarts of economic freedom and liberty. Therefore, fighting back against radical antitrust measures that can undermine Americans' freedom and prosperity is a must. Thank you.
All right. Thanks, Ashley, and thanks, Darren. I'll just jump into what I was going to say. I think this discussion is incredibly important, and so I think it's great that, Ashley, you've organized this and that we're doing this here today. I'm really glad that Darren's here and that the Heritage Foundation is represented. Obviously, the Heritage Foundation has done a tremendous amount for promoting conservative ideas. My first job in DC a while back now was with, before I joined Senator Elizabeth Dole's office, was with the American Enterprise Institute, another think tank. And that's where I first was introduced to kind of conservative think tanks and the tremendous amount of work that they do and Heritage does in particular. So I think it's great that Darren's here and that Heritage is here, because I think these ideas are incredibly important to discuss. And then maybe that's a long way of saying that I entirely agree with what Darren has to say and with the points that he's made. And maybe what I will do is kind of provide some additional perspective and amplify some points based on my experience as an antitrust litigator every day, or antitrust attorney every day, and as a former FTC employee and official. And I think I'll say at the start, I encourage everyone to go read a piece that Josh Wright and I wrote in National Affairs titled "A Time for Choosing: The Conservative Case Against Weaponizing Antitrust." That for those who it's missed on, it obviously borrows from Ronald Reagan's famous speech for Goldwater in the 60s. So I encourage everybody to go read that as well as Darren's piece, which is also fantastic. So I think what I want to leave everyone with, and maybe what Darren wants to leave as well, is why is the current flirtation by the right with kind of an expansive approach to antitrust? Why is that bad policy? Why is that not conservative? And why should we not kind of follow the progressives like Senator Sanders and Senator Warren down this path? And why we should kind of return to first principles in conservatism and antitrust. And I guess as a starting point, what do I mean by conservatism and conservative antitrust? I think maybe at the most basic level, American conservatism seeks to preserve or to conserve the principles of America's founding, right? So, the Constitution, the Declaration of Independence, the Bill of Rights, and those principles primarily were freedom and liberty, and the idea that the fruits of your labor are your own, that free markets matter, that the rule of law matters, and that the government works for us and not the other way around. And so I think when you're thinking about it in those terms, what kind of antitrust policy should conservatives be promoting, and what types of policy ideas should they be fighting against? And I think the most salient features of kind of the new progressive proposals, the proposals by the kind of school of antitrust thinkers who call themselves the new neo-Brandeisians, that are spearheaded by, at least in legislative circles, by the Senator Sanders and Senator Warren and those types. But as we've kind of mentioned, have also swept in some conservatives as well. Those ideas, the most salient features, are really kind of old wine in a new bottle, right? These ideas have been tried before, as Darren suggested. They've been tried 60, 80, 100 years ago, and they didn't turn out so well for us. And it was through persuasive thinking by leaders such as Scalia and Thomas and Bork and Easterbrook and Judge Doug Ginsburg that conservatives had an impact on reshaping antitrust policy and bringing it into kind of modernity and tethering it closely to economics and making it principled and tractable so that some of the problems that Darren mentioned weren't as prevalent, right? The idea that, you can have a vague and ambiguous standard in which regulators and judges could basically put their finger in the air and say, well, I can find any number of reasons to rule whichever way I want to because the standard is so flexible and malleable. Through the work of those conservative leaders, we got to the consumer welfare standard, which really did ground us into a more principled approach to antitrust. One way to think about the choices that we face today is, do you want a Wilsonian progressive approach to antitrust, or do you want a Reagan approach to antitrust? And that's kind of, that's putting it in stark terms and somewhat simplistic, but that's really what we're looking at. Do we want to go back to the 20s and 30s and 40s and the antitrust that grew up from that era, or do we want to double down on the economic revolution of the 80s that were led by conservative scholars and judges at that time? And some of the proposals that are coming out today are again, the same ones that we saw during the progressive era. They include, as Darren mentioned, as a key part of his talk, abandoning the consumer welfare standard and employing some sort of public interest test or bright line rules. It means banning mergers entirely. There have been calls for merger moratoriums in their entirety. There have been calls for reversing the burden of proof, right? So that the government doesn't, it's not that the government has to prove your merger or your conduct is anti-competitive. You now, as a business, as a private business, as the defendant, have to prove that your conduct is pro-competitive, which is really turning things on its head. There are proposals to give government more control in designing products, right? I can imagine what all of you would be using if the government designed your iPhone. It probably wouldn't work nearly as well or be as useful as you can imagine. There have been proposals for structural separation, kind of net neutrality types of regulatory regimes imposed on online platforms. To kind of allow the government to kind of decide, how private businesses operate in the marketplace. So these are all kind of new ideas that are being brought out, and I think they are, as Darren mentioned, they're motivated by an animus towards tech, or at least the kind of bipartisan aspect of it is, and I am certainly sympathetic to some of those aspects. But people also need to remember that this debate is not solely limited to tech, right? These proposals would touch every business that does, every company that does business in the United States. As Scalia, Justice Scalia once famously put in a dissent, this wolf comes as a wolf. This is going to be exactly what you think it's going to be, and it's a bit of the camel's nose under the tent, and we're going to embark on this path down kind of a liberal orthodoxy approach to antitrust, and eventually, that might seem fine while conservatives are in positions of power at the Federal Trade Commission or at the Department of Justice, but you can imagine how that world might change if you have individuals who have more progressive leanings and can use the expanded approach that has been kind of condoned under the antitrust laws to then target any number of conduct. And again, it becomes much less principled and more focused on personal preference and kind of a command and control economy at that point, right? Where you have government dictating winners and losers, and you don't have the free market and liberty principles that were kind of so core to our founding at the heart of antitrust as well. And I say that as somebody who deeply believes that antitrust has had a positive impact on the American economy and society, and think it's important that agencies such as the DOJ and the FTC enforce the antitrust laws fully to ensure that we promote competition and prevent collusive behavior and those types of things. So I'm not meaning to take away from that at all, but I think expanding antitrust and taking away some of the guardrails that keeps it focused on the good that has produced, and we could talk a bit more about the good that has been produced from the current economy. I think taking away those guardrails is potentially very dangerous.
Thank you, Jan, and thank you both for coming out, and thank you for your contributions recently to both of your papers and your written work. They were great and added really a lot to the conversation. So I was very pleased to see both of those being published. I felt they made a lot of really great points. So I'm going to kind of pick off a little bit where Jan was leading, and to make some remarks more broadly about the nature of conservative jurisprudence and how we got here and why this would be a bit irreversible, I suppose. You would say so, you look at any other area of the law, particularly civil law, torts, then it's kind of expanded a lot under the left. Like you look at environmental law, products liability law, any other area of law, but antitrust, we've actually managed to kind of rein in. And it doesn't really go that recognize that the consumer welfare standard, which is what kept antitrust law from kind of ballooning out of control, like you see in these environmental suits or any other suits that are and that don't really have a clear theory of harm, or depending on the area of law, there are different problems with the doctrine, but with antitrust, we've been able to implement a clear standard, and that was the consumer welfare standard. So essentially, we would be moving away from this, and we would be trying to weaponize it. And the left is a lot better than we are at weaponizing litigation. I mean, they have decades of experience at it, of course they are. But it's also, it's not just a matter of principle. And from a practical perspective, this is not going to work out well for us to start going down that path just for the sole purpose of going after one sector, which is a really small sector of the economy. Out of all mergers and acquisitions, for example, in the period the House Judiciary Report reported on the tech sector, I think it was like 0.5% of all worldwide during that same study period. And we're talking about actually a really small sector of economic activity here. And the standard that we're throwing aside, it's more flexible because of what conservatives believe. Then it allows the other side to implement, any sort of policy values into the law. You see this, you see the difference between the justices of the Supreme Court and how they interpret the law, and how some of them seem to not really understand the difference between policy and the law. But one day we're going to be in one case it was said that antitrust is meant to protect small dealers and worthy men. I'm not really sure what that means. It can mean a lot of things, but there are a lot of policy ideas that have been read into antitrust over the years. And eventually we got to the point in the 1960s, 1970s, where it was serving too many masters, and the law can't do that. So we went back to the system of consumer welfare. I'm going to take a step back and talk about a little bit about what the consumer welfare standard is. I think there's a little bit of misunderstanding about that, and there are disagreements over the technicalities, what it is. But for the purposes of this discussion, and for what is broadly accepted as, is it's not just the plus or minuses, is this good for the consumer sort of analysis. It's more of what guides the system as a whole, and how what the goal of the antitrust system is, which is to benefit the welfare of the consumer, and the system around which the rules of like liability and procedural mechanisms and presumptions are created. Like Jan was referring to, the presumption shifting burden. A lot of these things really go against the consumer welfare standard, or at least are and run around it, because they do things such as shift the burden of proof to the plaintiffs, which is a very to the defendants, which really goes against what our whole system of fairness and governance really means in the United States, and law as we know it. The burden shifting proposals, particularly, I think Jan might have some more statistics on this, being that you litigate these, but it's the proposals that have been put forth are not only against what we not only against the courts and our legal system, but they would make it impossible to win as a defendant. I think only 1 or 2 cases have been been successfully won by a defendant, like on pro-efficiencies defense. So the burden is it's really hard to win these cases if you're the defendant. And I think Justice Potter Stewart had his famous line that I referenced in the event description, that the only clear consistency is the government always wins. And the government still wins most of the time. And it wins in most of these mergers and acquisition cases. And it seems to be that there's this sort of myth that there's this huge litigation crisis in antitrust, and that the government's not bringing cases, or that they're having problems bringing cases, but they bring cases all the time. And to back up a little bit from that, antitrust law also has a deterrent effect, which is a good thing that the Consumer Welfare Standard has a deterrent effect, because it's clear enough to actually have a deterrent effect, and that a lot of M&As, for example, don't actually have it because they know that the government's going to pursue action against that company. So there's the deterrent effect, and then there's how things operate in court, in which there's clear procedural mechanisms here, and that we do not want to destroy, or that aren't really in line with some of the recent complaints. And you do have to prove harm to the consumer, and that's something that's really overlooked, is the need to prove harm. I'm going to kind of stop there and shift more to the discussions. There's this is a really broad topic, and there's a lot really that we could weigh in on, and I'd rather shift to the discussion here. But so Jan, can you address a little bit some of the questions that I had about litigation, and how there's no litigation crisis in antitrust, and the government has been bringing cases and has proper enforcement authority already?
Yeah, sure, happy to. And I think I'll first focus on the area of mergers, which has come into discussion a lot recently, right? We've talked, a lot of the popular press has been about the acquisition of nascent competitors, small fledgling competitors that could potentially grow into rivals against either big tech companies or in other spaces. You see this in tech, you see it in pharmaceuticals, for example, where you have pipeline drugs and things of that nature. And so M&A is really a hot topic in the antitrust world. And the reality is that the antitrust agencies already get a presumption, right? So there's the case Philadelphia National Bank, and there's the horizontal merger guidelines, which after the government proves a certain level of concentration, there's a presumption of harm that is generated from that, and then the defendants must rebut that presumption in order to prevail. And the reality in the case statistics is that the government overwhelmingly wins these merger challenges, and they have an enviable record. To be a bit immodest, we recently were in a merger litigation. We got a rare victory against the FTC, and the FTC comes and the DOJ comes into court with a tremendous amount of credibility, as they should, as enforcers in this area, and they've got tremendous resources, and so they're able to often, and the law on their side, and they are able to often win these cases. I think if you look over the last 10, 20 years, they're somewhere between 75% and 85% win rate, which is pretty enviable when you think sometimes these things should be a coin toss if they can't get to settlement. So I'm hesitant to say that the antitrust laws, at least in the merger, are broken based on that kind of litigation record. Now, I think we do need to do more to make sure that the agencies have resources to actually bring the cases that they need to bring. I think the DOJ and the FTC are strapped, and they shouldn't be losing cases because of lack of resources. And we do need to prioritize competition policy and their work.
Jared, do you have anything to add to that?
Well, not about the data per se, but I would just talk about the House subcommittee report that I referenced, the majority report. And there are some pretty extreme recommendations in that report. Like one of them is, so in terms of acquisitions, the report, this is what the report says, quote, recommends strengthening the Clayton Act to prohibit acquisition of potential rivals and nascent competitors, end quote. Now, I'm hoping that's not literally what they mean. And as I read the rest of the report after that line, it seems like it doesn't appear that the report is actually suggesting a blanket prohibition, although it certainly would make it much more difficult to acquire companies. So, and this report is not just about, and that recommendation is not just about big tech. And I think that kind of shows you kind of the motivation behind these recommendations in this report that's supposed to be about the digital market is actually making recommendations about the entire economy. So I don't know whether or not to take that as a blanket prohibition, but as I read the rest in the context of the report, it didn't quite seem that way, but it would, in essence, make it extremely difficult for mergers and acquisitions. And yes, it will hurt consumers. It will discourage entrepreneurs who actually want to start their companies. And in 2019, half of US startups across the economy said that their most realistic long-term goal is to be acquired. So what you'd be doing is you're making their desired exit strategy far less likely. And that's going to discourage entrepreneurs from starting a business in the first place. And we should be really thrilled about the fact that there's all these small little companies, these little guys flourishing in technology. And so why would we try to crush that success? And I think that's what some of these things, these recommendations would do.
Yeah, and if I could just chime in, I completely agree with that. I mean, ask yourself how many European tech companies is the EC or even the DOJ FTC pursuing antitrust cases against? None, because there are none, right? These are American-made companies because the innovation ecosystem here is more conducive. Now, that's not just regulatory overlay. I mean, that's a big part of it, but there are other aspects to that as well, whether it's kind of institutions of higher learning and research centers and other things. But the regulatory aspect is a huge piece to it. And I think Darren's right that you see a tremendous amount of investment, whether it's venture capital or other, into innovation and technology and into startups. And part of the reason that those investments are made is because of an aspiration to exit on the back end. Now, those exits shouldn't be anti-competitive, but we need to be careful about changing the friction in that M&A market to discourage that investment in innovation, right? So if you make it more difficult to invest, people are going to move their money somewhere else, whether it's Europe or to just other industries. And so I think we've got a fantastic thing going here in terms of innovation in the U.S. And now it could certainly get much better. I mean, there are legitimate claims about whether or not we're innovating in the right things, right? Should we be innovating less on social media and more in space technology or kind of driverless cars or whatever? But so I think there's some interesting debates about that. But there's no doubt that the U.S. is the leading force in innovation. Most R&D investment comes in the U.S. It comes from the U.S. and companies in the U.S. The GDP is largely grown by tech and innovation advances. So I think those are incredibly important and things we don't want to lose. Jobs, the app economy is $1 trillion industry worldwide and creates millions of jobs in the U.S. That's not something we want to lose. Platforms, online platforms make it easier for smaller businesses to reach consumers, not only in other parts of the country, but across the world, right? So you have small businesses who now, as a result of this tech, are able to grow their own business and be more successful. Now, none of this makes tech immune from the antitrust laws, by no means, but it is when you're thinking, and I want to be careful. I mean, a lot of what we're talking about is the changing antitrust policy, right? And when you're thinking about changing legislatively through rulemaking, however, there are trade-offs there. And when you're thinking about that, you have to be careful about whether or not those trade-offs are worth it and what kind of implications there could be. And I certainly don't want to suggest that these industries are somehow immune because they bring great things to us. They certainly bring great things, but they're also not immune. I also want to just talk on one thing about, we both Darren and I kind of went back to the early 20th century with antitrust, and And I'm sure there are some who are scratching their heads wondering, how can antitrust address tech issues that, we didn't know could be around, 20 years ago, much less 100 years ago. And I think that is the beauty of antitrust, is that the US statute is fairly short. It's been developed through the common law deliberatively over time through judge-made law, kind of in a conservative step-by-step incremental approach. And it is able to, and it was intentionally structured this way, to be updated as new business models came out, new economic information came out, right? The folks that drafted the Sherman Act didn't know about the app economy, and they knew they wouldn't know about that. And so the legislation was drafted this way so that it could be updated and incorporated. Now, there's nothing about the statute and about the modern economy that makes those antitrust laws inapplicable or unable to get to consumer harm broadly defined in the modern economy.
I think actually recently during Amy Coney Barrett's confirmation hearing, so she was asked a question by either Senator Hawley or Senator Klobuchar about what she knew about antitrust law kind of more broadly, and what she said was that she knew that the authors of the Sherman Act meant for it to be developed out by the courts in kind of a common law-like fashion, and she also gave a pretty good endorsement one or two times when she was asked about antitrust of the consumer welfare standard. I can't remember the exact quote right now, but she definitely expounded upon that. A couple of points regarding the EU and also M&As. With Europe, there's a lot of interesting data too regarding Europe and venture capital investments. Not necessarily in antitrust, but in the privacy context. I know if you look at the past 15 years or so of European privacy law, particularly the European Privacy Directive, like 2002 and forward, there's a very obvious drain of venture capital throughout certain periods of time. And I mean, that's one of just many examples. But with the M&A, with the bright line rules, I mean, it is difficult that you're essentially telling an entrepreneur, like, your only exit strategy is to fight your competitors to the death. And the competitors already like relatively large, like that's not a way to actually breed competition. No one will grow to compete with those competitors. We have quite a few questions here. One or two of them are directed at specific lawsuits and cases, and since we don't have time here to get into the merits of those and discuss them, I'm going to kind of bring it out to a more abstract level. But so some of the recent state antitrust lawsuits, the focus, according to this question, is it's on harm in consumer welfare and enforcement under current law. There isn't in either lawsuits to suggest the AGs want to change the standard for enforcement. Do you believe these antitrust actions are consistent with conservative legal philosophy? I guess maybe if either of you want to weigh in on the broader issues, such as the buy and bury strategy, or the core issues that are at the core of those suits, and kind of the tension there.
I'll let you go, Jan.
Yeah, I mean, so these cases, and again, I'm not going to speak in detail because we could probably have a couple hours on each one to actually give them the time they need. But these cases, yeah, they're brought under the existing laws, so they're not the product of some of this some of this new thinking on antitrust and the new proposals. I'll just make a side note quickly that the new proposals, maybe the most damning thing about them is that they're not necessarily about the acquisition by a company of a competitor, right? The new proposals would make it more difficult for a company to acquire any company, even if they don't compete. It's the concerns that are being raised are about bigness and the size of companies, and even it's unrelated to whether or not it's a reduction in competition. It's opposition to corporate bigness and growth. So that's kind of a side note. But in terms of these cases, without getting into too much detail, right? I think some of them present M&A issues and cases and issues in which the government had reviewed the transactions at issue 8 years ago in detail and had a substantial number of the documents that are cited. And so it raises kind of questions of certainty and rule and what can companies take away from the prior regulatory clearances they've received, or decisions not to challenge, I suppose, more technically. And does that uncertainty then create, again, friction in the M&A market? And then, these, I think from a conservative standpoint, the concern is always that the government in its actions may be doing more harm than good, right? And getting that these errors have reverberating effects and effects on chilling innovation and entrepreneurship down the road. And I think that's a particular danger in kind of dynamic industries such as tech. And I think it makes those cases inherently more difficult. It doesn't mean that they're not immune from the antitrust laws. It just makes the analysis more difficult and the decision by enforcers more difficult on whether to go forward.
I just want to add on the M&A stuff. I mean, we talk a lot about from the consumer welfare perspective, but one of the big issues is the fact that the companies, businesses making voluntary and free transactions on their own should be able to do so. And if the government wants to try to block these types of actions, it should be their burden to do so. It shouldn't be the company that should have to justify basically trying to engage in business. And so that's not, I think that's a bad standard, bad precedent to set. And also, I did want to reiterate the point that I think, Jan, you made earlier, is that we're focusing, I'm really focusing on attempts to expand, to radically change the existing antitrust law. And I'm not talking about the existing statutes as they exist today. My concern is not even necessarily the courts or the way it would be abused by the agencies, because quite honestly, the issue is really about Congress creating a framework that would allow the agencies and people bringing lawsuits to actually bring them for almost any potential reason, and to make it very difficult to engage in kind of free enterprise. And, we talked about the flexibility of antitrust law. Now, the beauty of the consumer welfare standard is that it's flexible, but it provides some type of focus. It gives you something to kind of, analyze these cases. But if you have kind of this vague societal objectives, and you're not even looking at economic factors, you're looking at non-economic issues, you're not just flexible, you have nothing there. There's no underlying philosophy to guide the analysis as you try to enforce the law. That's a problem. And if you could think about, when progressives trying to make those decisions, first of all, you can just pick winners and losers. You can decide we just don't like this industry over this other industry. Or you can have a bunch of companies coming to the government saying, hey, can you enforce this law against this other company? And then if you think cronyism in the swamp is bad now, it would really get swampy here in DC. So that's a real issue. So when they talk about trying to change the antitrust law to deal political corruption, I think trying to change it the way they would like to, I think is just inviting political corruption, because you just have all kinds of rent seeking going on. So yeah. Sorry, go ahead.
No, I completely agree with that point. And part of, that's been part of the benefit of incorporating economics into antitrust and having a more economic approach. And that has kind of created a common language, so to speak, for antitrust decision making. And it's something that the FCC has recently adopted. Chairman Pai has created an economics bureau within the FCC, having seen how well it works at the FTC and DOJ in the decision-making process. And that's somewhere where we're seeing kind of the conservative ideas from antitrust kind of being expanded to other areas of the administrative state, so to speak, and helping to make better decisions, I think, rather than kind of the FCC, which does have a public interest standard in a lot of ways, and so helping kind of create more of an economic foundation for those decisions, I think, is helpful. And again, it kind of avoids some of the limits the rent-seeking capabilities, right?
Yeah, and regarding the M&A's issue, and to tie that back into kind of the broader legal issues that we're touching on, and the nascent competitors strategy or acquisitions, it's, you can't prove harm based on harm in a hypothetical world that doesn't exist. You can't say this small company that's at the time was nothing would have grown to be successful, because there's no evidence that it would have done that. And changing some of the mergers guidelines, you have the bright line rules that make it kind of impossible. And then there are also things they're trying to get rid of, such as, for example, there's something called the failing firm defense, and that would be particularly bad to get rid of during COVID, particularly. But some of the thoughts behind that too are also just about hypotheticals, and that's not. I'm confident. I mean, like Darren, I'm more concerned actually about what Congress could do, or these broader changes to the doctrine, because these suits will eventually, if the law is applied correctly, then I have faith in that system. But we would really be undermining that through a lot of the changes that are being proposed right now. And a lot of it too, when you're looking at these acquisitions that kind of could have been, so all these suits and this whole debate over M&As reminds me a lot of this quote from Wild Coast that I really like. I think it's, if you torture the data long enough, then eventually it will confess. And that's kind of what we're seeing here. If you're looking at just through a lens of one specific industry, or through a lens of some sort of, it could have been this big. And we need those very strict guidelines that we already have, and our system and that works both in the courtroom and with economic analysis as well. Let's see, we have quite a few new questions here.
Maybe while you consider the question, the only thing I would add to that is that all merger review is forward-looking, right? It's perspective. We're trying to, and most, at least most, when you're not thinking about consummated deals, you're thinking about what's the world going to look like after the transaction, and is that going to be more harmful to consumers or not? That can be a challenging analysis as it is. And when you think about more dynamic industries, it gets even more challenging. When you think about nascent competition, that gets even more challenging. When you think about industries that don't even exist, it gets more challenging. When I was at the FTC, we actually challenged and got a consent in a case in which the alleged market didn't exist, but the two companies were clearly kind of, according to the agency, developing products that would eventually be in that space. Now that's really challenging analysis, but the antitrust laws are capable of doing that if you have the evidence. And I think that, I think the cases we're seeing now are going to be very fact specific, and I think it's hard for any of us to kind of weigh in on where they're going without knowing the facts.
Yeah, there's a lot of unknowns now too. I mean, we know the broader theories, but not necessarily the facts of the cases yet. So hard to weigh in there. Let's see, there's a question for Darren that says the Heritage Report states the misguided attempts to change antitrust law in order to target the technology sector should be considered in light of the technology sector's numerous benefits to the country. The consumer benefits are especially relevant given that the purpose of antitrust law is to promote consumer welfare. Do you think the consumer welfare standard needs to be better explained and its history made more clear?
I think that one of the reasons why we're having events like this event today and we're writing the papers is to try to help explain the consumer welfare standard. And I think there's certainly more that I could be doing to try to explain it better. I think that is important for us to communicate this well. And I would, not to disagree with myself in that paper, but and I don't, but I think I would just stress that just because the technology sector provides benefits isn't necessarily a reason why, we don't worry about, they don't apply the antitrust law to them, whatever. Well, we do apply antitrust law to them. The fact, in that section of the paper, that was after we were kind of laid out why it was so important to stick to the consumer welfare standard. And that section is about the context to look at all of this, because I think one thing, and now I'm glad that you actually brought that up, about the benefits of big tech, is that I constantly hear about how the US needs to remain the leader in technology and innovation. But right now, what we're doing is we're threatening us maintaining the leadership in technology and innovation. And, this has been brought up about how we are the leader. Almost half of the 2019 top 50 digital companies listed by Forbes were American businesses. If you just think about the pandemic a second and what it's been like living during the pandemic, imagine if you didn't have all the innovations and the technology that we had right now, just being able to have things delivered to us and staying in touch with people and holding virtual meetings and telemedicine, distance learning. There are all kinds of benefits, and there's a reason why we want to be a leader in the technology side. And that's not a reason not to properly apply antitrust law, but we certainly should apply antitrust law just like we would for anybody else. But I think it does show certainly the incredible benefits that the technology sector does provide consumers. And I think if enforcers are going to enforce the antitrust law, they should be asking the question, how does this actually benefit consumers? How does this even help anybody? What is the point? And one key point I don't think we've mentioned yet is that antitrust law is about focusing on the competitive process, not the competitors within the competitive process. So we shouldn't be analyzing, well, how does this impact business A as opposed to business B? That's not what the purpose is. It's about how does it impact competition, the process itself, and also the consumers. How do American families get impacted by this?
And that's one major difference between antitrust law, like in the United States and in the EU. In the EU, you can't harm a competitor, essentially. That's kind of oversimplifying it. But in the United States, it's not illegal to harm a competitor, so to speak. I mean, that is the competitive process. We have a rigorous competitive process here. It's the consumer that it's oriented around. And that's a really important distinction. And Darren, by the way, I didn't read your papers saying that it's not worth changing things because the tech sector is so important. It's more that don't obliterate the law, because then you're going to ruin both the law and then the economy, and also it's bad for consumers. So
well, that's good. I'm glad I got it right.
Part B, yeah.
Yeah, and I think one thing we're really talking about is, the antitrust laws are what they are now, and I don't think anybody here opposes that they are fully enforced. And different people will have different views on the margin as to how they should be enforced and when a case is appropriate and when it's not appropriate. And that's a healthy, I think, and good debate to have. I think what the recent spotlight that's been shown on antitrust has really created all these proposals to change antitrust and either to return it to what it was in the progressive era, the pre-economic revolution in the Reagan era, or to make other changes. And I think what we're kind of agreeing on here is that those additional changes are A, unnecessary because the antitrust laws are capable of dealing with these issues, and B, potentially dangerous, right? And Justice Scalia, again, I've already cited him once, but he agreed that the antitrust laws are kind of the Magna Carta of free enterprise, but also said it was completely inappropriate for judges and I think in a lot of ways legislatures and regulators to decide how businesses should operate. That's not their specialty. That's not, again, you don't want the government designing your iPhone. You don't want the government making those types of product design decisions. And that's inherently going to happen if you tweak the antitrust laws so much so that you've got more command and control of the economy.
Could I add something, Ashley? That's right. One of the really big points I'd like to make today, and I kind of did before, but is I know some conservatives are concerned about big tech. They're mad at them. And I think some on the left are kind of on the far left would love to kind of have a very weaponized antitrust law. And then, so they'll have this little Trojan horse that they'll, and they'll provide it to some of these conservatives, and conservatives will be like, yay, it's anti-big tech and whatever. And then all of a sudden, Senator Warren and Sanders and Nancy Pelosi are going to jump out, and then they're going to basically use antitrust law to go way beyond big tech and impact the entire economy. They can pick any industries they want. Plus, it's not just going to be, well, what's competitive, what's not. It's not going to be questions about how to make the better iPhone, what industry should look like in big tech. It could be things like, we think certain, you're not investing, we don't want companies to be using fossil fuels or something like that. And we don't think the market should be so fossil fuel, focused, or that, we want more unionized labor markets. And the industry, a particular industry, should reflect that. If you allow it to be basically carte blanche to the government, and Congress allows that to happen, then that's what potentially is the result. That's what I'm concerned about, is how broad that power can be in terms of the substance. Basically, pretty much anything could be the justification for messing around with an industry. And it's the fact that it could be any industry, not just big tech. Now I'm concerned about big tech in the technology sector, but I'm concerned about all sectors of the economy.
Yeah, and kind of to tie that back in to what I was saying at the beginning is, any like socioeconomic cause that you can imagine can be one way or another achieved, or it could be attempted to be achieved through competition law, through the entry point of the economy. So, and then also like any sort of like business transaction that you can imagine, just any sort of hypothetical, is probably illegal technically in the 1960s and early 70s, because there was no standard in which to go by, and that's why we have these guardrails now. And that's, it's nice. There's kind of perfect merging of law and economics that kind of led to this thing. But as conservatives, we're also very much against using the law for things that the law is not for. And I think if you want to go after speech issues, then use those appropriate avenues. I mean, that's fine. Or privacy or whatever other completely divorced from the competition process issue there is. There are other ways to pursue that. And whether or not you should, that's a completely different debate that we can't have right now, because there are so many concerns. But competition law should be for the competitive process.
It's an extremely important point. I mean, I'm not saying that on the right there are, we need identify the policy problem, the specific policy problem that you're concerned with, and then identify a narrow response. First, I'll figure out whether or not it requires a governmental response. And if it does, then figure out the narrow solution to address that issue. So if, for example, the left is concerned about labor issues or political corruption, then address those issues accordingly. And the same thing goes with folks on the conservative side. If we're concerned about certain censorship issues, figure out if there is a policy solution, address it specifically. Don't use antitrust law, which has nothing to do with those issues.
Yes, especially after what it took to get from 1890 to the Consumer Welfare Center. I know going back to what you're saying about more education over antitrust law, I've been asked a lot recently about, what about a textualist application of the Sherman Act? I'm like, let's talk a little bit about 1890 to about 1910, because you literally cannot apply it that way because it was not meant to be applied that way. Does anyone have any quick closing thoughts? I think we're running up against the end of our hour.
I mean, I'll just say again, read my paper, read Darren's paper. I think they're both interesting. And again, I think if you're, it's as we say in our paper, it's a bit of a time for choosing. And I think conservatives who are interested in antitrust policy need to figure out if they have a newfound faith in kind of central planning and those types of principles, or if they have if they want to stay committed to limited government and free markets. And And that's, when you're thinking about these new proposals for antitrust, I think that's kind of at the high level, the distinction between the paths going forward.
Right, it's time to make a decision, as you said. Darren?
I would just add, I appreciate again the concern regarding big tech and speech issues. I definitely appreciate that. But let's not adopt bad policy as a solution to those concerns. And finally, I want to thank you, Ashley, and Jan, and all of you today for participating. And just thank you for inviting me.
And thank you for coming. I'd like to thank both of you.
Oh, yeah, read my paper and read Jan's paper.
Yes, I put it in the chat for everyone. And I can also send it out in the post attendance link that Zoom generates so that you guys will get a copy of both of them. And the video will be online actually on the Committee for Justice's YouTube channel, which you can find on YouTube if you just look for the Committee for Justice or open the email that you were sent after joining, and it'll be there for later viewing and all of our former antitrust work and future antitrust work as well. Thank you and have a good afternoon.
Thanks.
Thank you.